Let's talk about your rights in the criminal justice system. When it comes to being accused of a crime in the United States, a lot of your rights come from the Bill of Rights, the first 10 amendments to the Constitution. Some additional rights come from state laws and constitutions. Originally, these rights only applied to cases involving the federal government, but over time, the United States Supreme Court has made almost all of them apply to state cases too. The one exception is the right to be charged by a grand jury, which still only applies at the federal level. The 14th Amendment, added in 1868, changed the game. After the Civil War, it raised an important question: should the rights in the Bill of Rights also protect people in state courts? Eventually, starting in the 1960s, the Supreme Court said yes, and began making many of those protections apply to state criminal cases through a process called selective incorporation. Let's now move to the Fourth Amendment. The Fourth Amendment protects you from unreasonable searches and seizures by the government. Here's what that means. 1. A search is when police look for evidence, like going through your car, house, or backpack. And 2. A seizure is when they take your property or arrest you. To do either legally, police usually need a warrant, a court order based on probable cause, which means there's solid evidence a crime happened and that evidence, or the suspect, is in a specific place. There are, however, exceptions. There are some situations where police can act without a warrant, like if you give consent, if something is in plain view, if there's an emergency, like someone destroying evidence, if they're chasing a suspect, called hot pursuit. Most arrests actually happen without warrants, but officers still need probable cause. If someone is arrested this way and held in custody, a judge has to review the arrest soon after to make sure it was legal. The law uses different levels of proof depending on the situation. Professor Rees insists that you understand these levels, especially if you plan to work in the criminal justice field. Here they are. 1. Mere suspicion, just a hunch, not enough to stop someone. 2. Reasonable suspicion, enough to stop and maybe frisk someone, a quick check for weapons. 3. Probable cause, needed to make an arrest or get a warrant. 4. Preponderance of the evidence, more than 50% likely, used in civil cases. 5. Clear and convincing evidence, strong proof, used in some legal situations. 6. Beyond a reasonable doubt, the highest level of proof, used to convict someone in a criminal trial. 7. Proof evident, presumption great, used to deny bail in serious cases like murder. If police break the rules, like searching without a warrant when they need one, any evidence they find can't be used in court. This is called the exclusionary rule. It's meant to discourage police from violating people's rights. There are a few exceptions. Good faith, if officers thought they were following the rules. Inevitable discovery, if the evidence would have been found legally anyway. After the 9/11 attacks, Congress passed the USA Patriot Act. It gave government agencies like the FBI and CIA more power to spy on people, including United States citizens. It also reduced court oversight and made it harder to challenge government surveillance. Many of its parts were supposed to expire, but have been renewed or made permanent. Understanding these rights isn't just for lawyers, it's for everyone, especially students like you. Knowing what the law allows, and what it doesn't, helps you protect yourself and hold others accountable. Now, study this section carefully before moving on.